Welcome to episode 2 of Obiter, the Durham University Pro Bono Society podcast. My name is Jeffrey Kaur.
My name is Stacey Stroud.
And today we have here with us Professor Fiona de Londras. She specialises in human rights and constitutional law. Much of her work is on how individual rights are affected in times of crises. She's published in various notable journals like the Oxford Journal of Legal Studies and the Modern Law Review, Human Rights Quarterly as well. She's currently writing a book on privatized sovereign performance, Counter-Terrorism and endangered rights. It's to be published later this year. A lot of what we're going to discuss today will be published in this book. Thank you so much for being here with us, Professor de Londras. And we're going to start with some very broad questions about counter-terrorism and individual rights. So to start with, what actions can a government legally take in order to counter terrorism?
The answer to that is deceptively complex, because the simple answer is to say that a government can do anything that it considers it needs to do, provided it doesn't step outside whatever the constitutional limits are that it acts within. So in some states that will be a written constitution. In other states it will be something like a Human Rights Act, or that combined with international human rights law obligations. But effectively states can and do whatever they consider to be necessary up to and sometimes beyond the boundary of what they are strictly legally permitted to do. Mm-hmm. That boundary is largely made up of rights-based provisions found, as I said, in constitutions or statutes or international human rights law.
Okay, so what sort of rights are we talking about here that are affected by counter-terrorism policies?
Well, counter-terrorism affects rights across a number of dimensions. The first is the individual people who are suspected of engagement in terrorism. For those, we see counter-terrorist measures that typically will infringe on their right to liberty because of long periods of detention, fair trial, or at least what we consider to be the normal ingredients of a trial, privacy, respect for the home, family life, and so on. We sometimes, for those individuals, also have measures that implicate really core rights that we are never permitted, in fact, to violate, such as the right to be free from torture. The second group of people then who are affected are the sort of family or the immediate community of that individual, where you have a cascading effect of rights violations. So in many families, if a person is identified as a suspected terrorist, picked up, detained, that will have immediate economic impacts for the family. It will also have impacts for the family's privacy, freedom of movement, communication, and so on, because the house might be under surveillance or what have you. You also have impacts for community, particularly in the context of terrorism. We often see the representation of terrorist threats as coming from particular communities. So nowadays the Muslim community is considered what Paddy Hilliard used to call a suspect community. In the 80s here in Britain it would have been Irish people in particular, and an entire community begins to suffer from racism or particular approaches to policing and so on. And then we have the broader implications that we all suffer, even though we don't necessarily recognise it, because the general level of rights protection and respect for the concept of rights tends to deteriorate somewhat in the context of counter-terrorism.
Wow, so it's actually such a huge spectrum of rights that is affected. So how does an individual protect themselves against these policies, or rather, how does an individual challenge an infringement of these rights in the context of counter-terrorism?
Yeah, it is challenging. If one is the immediate target of counter-terrorist action, so for example detained or subjected to a control order or something like that, the legal structure that allows for that counter-terrorist measure can have an appeal process or a review process within it, and that would be your first port of call. But of course you also can challenge the validity of the measure against those boundaries we spoke about earlier on, either a constitutional challenge or a Human Rights Act challenge, or go to the European Court of Human Rights, for example. Beyond the legal challenges, we also have political challenge through advocacy, organisation, engagement with individual MPs, and so on. Although in the context of the individual suspected terrorist, there is a challenge in trying to get political support for your cause, particularly from elected members of parliament, for example.
So these different methods that you've talked about, which do you think are the most effective, and or maybe which do you think should be improved?
Well, they could all do with improvement. When it comes to using courts could be more, what I call more muscular, in the way that they approach counterterrorism. Politicians could be less populist in the way that they approach them. The people at large could be more reflective and less panicky about the way that they react to rights-based claims. There is improvement required across the line. And in some senses, the improvement is the same at every level, and the requirement for improvement is the same at every level. And that core requirement is the acceptance that terrorism is not something that we can litigate out of possibility, that it is a risk. It will always be a risk. It has always been a risk. And what we have to do is manage that risk. We cannot eliminate it. And when we focus on trying to eliminate it, we allow the management to go beyond those boundaries. So until we come to an acceptance, not a resignation to violence, but an acceptance of risk, then none of these micro improvements will really be possible.
Yeah. So it's also about the collective attitude of the public, as
Absolutely.
you said. So not being panicky about it. So I think we'll move on now to 3 specific aspects of counterterrorism, and that's surveillance, and then the thing that you call privatized sovereign performance, and finally extraordinary rendition.
Yes, so if we'd like to start with surveillance, because it's very interesting, because nowadays we're definitely in an age of constant technological advancement, and it plays a really dominant role in our everyday lives, and I think it's possibly so pervasive that we often don't recognise it as having such an influence, but it does, and perhaps we underestimate just how pervasive it is. But how would you say that these new technologies have influenced or impacted counter-terrorist surveillance?
Yeah, I think there are probably 2 ways, generally speaking. The first is that through our engagement with these sorts of technologies, Facebook, Twitter, checking in on phones, things that we sort of do on a fairly regular basis, we are voluntarily surrendering information about ourselves, about our location, our activities, our beliefs, our sentiments, to somebody or something out there, without necessarily thinking through what the implications of that are. So that's the first way, is that the technology has probably changed the way we behave and changed the way that we conceive of privacy. And that's not a new thing to say, really. It's been written about in lots of contexts before. The second way, though, is that those technologies can also be used by states as a mechanism of surveillance. So there is this sort of passively allowing ourselves to be surveilled by giving all this information. But then there's a more active use of technology for surveillance. So a lot of states, for example, run sophisticated sentiment analysis programs, which are essentially looking at sentiment across social media, blogs, forums, Twitter, Facebook, LinkedIn, the whole shebang. Lots of things probably I don't know about also. So there's active information gathering through those technologies. There can also be the use of those technologies to engage in stings, to engage in direct spying. So there's lots of ways, not necessarily negative, in which technology enables surveillance.
Yes, and you say that not necessarily negative. So do you think that states should have the right to collate and use these identifying informations, or do you think that they should have it to the extent that they currently do?
Well, I'm not sure that we are precisely clear on the extent to which states do have the legal entitlement to use all of these types of information. And that's largely to do with the nature of the internet as a kind of difficult governance space, right? We have a lot to figure out about jurisdiction and things like that. Do I think that states should be able to collate information in this way? Well, to an extent, yes. We must always bear in mind when we are talking about rights and terrorism that states are largely well-meaning, that there is a threat, that states do have a job to protect us from, and that really we would rather like that they did that job, and that they did it well. But it comes back to those boundaries we spoke about earlier, those limits. Where do the limits go? Where do we set those limits? And that is a more difficult question. So, should states be able to do this? Yes. Should they be able to do it in the way that they can now, where there isn't full transparency and there are odd interactions with private entities, which I know we'll speak about in a while? No, I would rather see that structured and overseen in a more traditional way. Mm-hmm.
So would you say that citizens have any control over what personal information the government can use and how they can use it? Is there a way they can challenge the government's use of this information?
Yeah, they can stop using the internet.
Is there any other way they could challenge it?
Yeah, there is. I'm being a little bit facetious. Although that is an important part of it, actually, is to recognise what we're doing when we're engaging with technology. But of course you can use privacy rights, the Constitution, human rights, data protection. All those same tools that we normally use can also be used to try to push back against or at least force some sort of limitation on surveillance.
But at the same time, do you think there should be more individual awareness of what information people are putting out there about themselves?
Absolutely. I think people need to be a lot more plugged in to the way that our interaction with the ether is an interaction with the state.
Absolutely. Thank you very much. Okay, so we're going to move on now to something which is called privatized sovereign performance. When I first read that phrase, I was terrified, and I thought I have no idea what that means. But you've definitely done a lot of work on it, and it's very interesting. So, JP, if you'd like to take it on.
Yeah, I guess we'll start with defining it. So can you, as simply as you can, I know it's a very, you're writing a whole book on it, so it's a very complex area, but to the ordinary citizen, what does privatized sovereign performance mean?
For me, privatized sovereign performance, which is a phrase that I just made up, it's an original sort of way to try to conceptualize something that I see happening, is in a general sense the movement of activity into a space that is difficult to see, the removal of activity from the public gaze. And the idea of the public gaze there is influenced by the work of a brilliant German philosopher, Hannah Arendt, who spoke about and wrote about the concept of the public. And the public is a place for her of seeing, and that which is seen must be justified, and that which must be justified can be judged, right? So for me it's about transparency. And so privatized sovereign performance is essentially the undertaking of activity on behalf of or by the state without any transparency. It can be done by private actors like companies, but it would also capture really covert agencies like intelligence agencies.
Okay. So, we were just talking about surveillance. Where does this divide between private and public lie? If something is done by the state, is it inherently a public act?
Now, if something is done by the state or not by the state is a separate question in a way to whether something is inherently public or inherently private.
Okay.
So there is the traditional sort of conception of the public and the private, which law loves because it's nice and straightforward. Public equals state, private equals not state. Public equals loads of public law, private equals lots of other kinds of law. That's law likes that, nice and straightforward, easy to manage. But reality is not at all like as simple as law would like it to be for purposes of management. So I'm not sure that there are any acts that are inherently public or inherently private. which is why I try to talk about acts that are sovereign, acts that express a power, right? And lots of those are acts that we would traditionally have seen as done by the state. So imprisonment, coercion, surveillance, spying. These are all things that are expressions of sovereignty, traditionally done by the state and increasingly done in a privatized way. In other words, either covertly by secretive parts of the state or by non-state actors. So it's a different question to what's the difference between public and private. What I'm trying to do, because I think public and private is not that helpful for us, is I'm trying to say let's just get away from public and private and think about seen and unseen and look at it in that way.
So what are the activities that the state does that are not seen? What do they do that's outside the public gaze?
A huge amount, actually. From very pedestrian things to quite extreme things. So to take something on the fairly pedestrian side of the scale, if you fly anywhere within, let's say, the Schengen zone, so you're within, now the UK and Ireland aren't in Schengen, but let's say you're in a part of the Schengen zone and you fly from one country to another, the only party that is likely to ever check your right to fly, your right to cross that border, is somebody who works for an airline company and checks your passport as part of checking you in to the flight. Now, that then feels like a fairly routine thing for an airline to do. They're just checking that you are the person on the ticket and that you're flying. But actually, if you present without the correct visa, or your passport is out of date, or your passport is not sufficiently in date for the country that you're going to, then the airline will do a border control job for the state. But we don't see it as that. So that's, one not hugely problematic example. On the more extreme side, we have companies that, as part of their job, gather lots of information. Like a telecoms company gathers lots of information about who we call and where we are when we make a call or send a text or whatever. And that, if the state did it, we would call that spying. We would call that surveillance. But when a company does it, it's just running their utility that they provide to us. So when that company has that large body of information, a state can simply ask for it. And we saw this in the United States after 9/11 with the President's Surveillance Program, which was essentially just quiet requests without legal basis to large companies like AT&T to hand over reams of data, which were handed over. So, as now that's worrying. Simply making sure that your passport is in date, not as worrying.
Yeah, so to contextualize this and bring it back to what you call privatized sovereign performance, would an act like contacting a private company, like AT&T, would that be a private act but done with a sovereign power and therefore be categorized as privatized sovereign performance?
I think what it would be is, once the state gathers the information from the company, what it would be is an unseen exercise of sovereign power. Because it is the state effectively surveilling us, but without us seeing the state. So to give you an example that I find makes sense to me when I'm trying to work my way through this, we can compare going up to a uniformed police officer on the street and saying, "Hello, officer, could you advise me on how to make a bomb?" Not advisable, really. Because that person is likely to say, "Let's go to the police station and talk about it," and you've now become a subject of state interest, and you know it, right? Because the police officer is manifestly the state. He or she is standing there in a uniform with a constabulary badge. You know what you're doing. But if you just Google how to make a bomb, and for some reason at some point the state says, "Could you tell me something about the search terms that this person has used?" and Google just hands it all over, I haven't interacted with the state there. I've just Googled something kind of stupid, how do you make a bomb? But somehow that interaction, that curiosity, becomes something the state knows about me, even though I never manifestly engaged with the state.
Yeah.
So for me, that's the difference. You see the engagement when it's manifest, and you don't when it's privatized in that way.
Yeah, and I guess the consequence, like you said earlier, is when something is not seen, you can't judge it, and therefore you get a problem with transparency.
Precisely, and it doesn't have to be justified, because the way we know about lots of these things is by accident. It's by leaks, or by freedom of information, or by a whistleblower. Who knows how much privatized sovereign performance is happening that we know nothing about. Let's say you're looking at flights to go to a conference in Washington, and at the same time you're writing a paper for a class where you say, I wonder how easy is it to get information about how to become a fundamentalist terrorist, or how to do a suicide bombing, and you kind of do loads of Googling on that, and then you've done something else funny or odd, like you've used your credit card at a hardware store to buy a pile of petroleum and whatever it takes to make a bomb, and somehow a flag goes up against your name for some visa infringement or something, and in some way, some convoluted way, lots of these kinds of information start to come together. The fact that from your internet cache we can see that you were looking at flights to Washington, you were searching up stuff about suicide bombing and how to make a bomb and fundamentalism, and then you also bought all this stuff in a hardware store. And even though none of those things are connected, in a suspicious way in reality, through an algorithm they can look deeply connected. And you add to that things that place you within a suspect community, like being the right age or the right colour or the right religion, and suddenly you are a suspect.
Yeah.
That is, it's a little bit convoluted, but it's not beyond what happens.
And that brings us very nicely to the third part of this interview, and that's extraordinary rendition.
Yes, now, extraordinary rendition, what is it? It's a very simple question, but it's a very complicated answer. So would you be able to explain what extraordinary rendition is?
Well, extraordinary rendition as a phrase is a euphemism. It's a euphemism for the transfer of individuals without process across borders in order to interrogate them, often, although not always, involving the use of torture against the individual, but always involving a lack of process, lack of legal representation, and holding someone incommunicado.
And you say a lack of legal representation and lack of process, but does that mean that extraordinary rendition is illegal?
Extraordinary rendition has been deemed illegal by every international legal body that has considered it. And there are a number of ways to see the illegality. You have usually some kind of infringement on another state's sovereignty. So you go in and grab a person from that state, your agents don't have clearance to do it, there's an infringement of sovereignty. That's one simple illegality. You also have mass and multiple violations of rights when it comes to the person who has been rendered, or the rendee, as they're known. So their freedom from tortures often violated, the right to representation, right to be free from arbitrary detention, right to fair process, all of these things are violated. And so even if the concept of extraordinary rendition itself were not illegal, and we believe it is, then lots of things that happen within it would be multiple cumulative illegal acts.
Okay, so if it's been defined as illegal and the understanding generally is that it is illegal, then is it still taking place? How widespread is extraordinary rendition?
Right now we don't precisely know how widespread it is. The former president finally made public the extraordinary rendition, or known as the high value detainee program, in 2006. The suggestion was that President Obama was stopping rendition and replacing it largely with drone strikes instead, which is not any better, but nevertheless. There are now some indications that at least some people are being rendered, or something like extraordinary rendition, under the Obama regime. We also know that there are extraordinary rendition-like activities that happen around the Horn of Africa or in sub-Saharan Africa as well. So we don't know how widespread it is. We think it probably still happens to some extent, but most likely not to as great an extent as it did in the first 5 years of the war against terrorism.
Okay, so is it very easy with extraordinary rendition to identify who is doing it or who is taking part? Or is it actually going down the rabbit hole? Is it a lot of people involved?
It's an enormous infrastructure, extraordinary rendition. You have a number of states involved. You have the detaining state. You have the state to which the person is brought. Sometimes there are a number of states where somebody ends up being held. You have lots of states in between, transit states that allow for planes to use their airspace or refuel or what have you. Within those different states, you have different elements of the state involved. Largely, although not exclusively, those really covert or secretive elements we were talking about earlier, like intelligence services. You have a number of private companies that can sometimes be involved through the provision of logistics or flight plans or aircraft themselves, sometimes through the provision of security. You have the security forces in holding states that will sometimes actually interrogate the person. You have this enormous sort of structure of rendition that makes it almost impossible to see the full chain of involvement in any particular case of rendition, although you can see parts of it, but also suggest that the scale of this thing could not have really been unknown at the time of its height, because it just requires so many entities for it to work.
So in the face of this huge infrastructure, how much power can one citizen have? Is there, again, I always refer to it, is there any way a citizen can protect against extraordinary rendition?
Protect oneself as a rendee? Not really, at the time. When people are released, as often happens, then something different can happen. So sometimes people are released and they're put under gagging orders. Now, not legal gagging orders, they're just told, don't talk. And depending on the context in which somebody lives, that can be really effective. So, for example, I did some research in Pakistan in early 2006, where you would talk to people who had been held or rendered across the border in Afghanistan or elsewhere into Pakistan, and you would ask them to tell you about it, and they simply would not talk. Nothing on earth would get them to talk. Whereas people who are in different contexts, and that's not so much the case anymore. It was a different world in Pakistan at that time. You have, at the same time, people in different contexts who do take action. So El Masri is an excellent example, a guy who was not only extraordinarily rendered, but afterwards, it transpired that he was the victim of a case of mistaken identity, and he ended up with a case in the European Court of Human Rights, which he won. The first case to come before the court, precisely on the point of rendition, and an absolutely overwhelming finding by the European Court of Human Rights in December of a violation against the former Yugoslav Republic of Macedonia for their involvement in rendition. So after the fact, people who have the right circumstances around them can try to do something. It doesn't always succeed in terms of remedy, but it does shed some light. This kind of picture is ever growing about what's been happening. But at the time that you're identified and rendered, there's nothing you can do. I mean, you are powerless. You're incommunicato. There's nothing you can do. Your family can try to lobby, but
generally you're quite powerless.
Absolutely, of course, you're rendered powerless by this conglomeration of states and corporate power that are acting against you.
Yeah, absolutely. It's not one person that's rendering you. It's like you said, an enormous infrastructure.
And I think that's one of the things that's really interesting. As we've gone through this interview, you start off with what seems to be like basic rights and things that should be easy to protect against. And then as you develop, you see that, in fact, the state has got so much influence and so much power.
And it's not just one state.
It's not just one state, it's multiple states, a huge infrastructure. And so often we don't realise it.
Yeah. So if you are interested in this, look out for Professor de Londras' book. Do we know details? Not
It
yet.
will be published actually in January of 2014 by Cambridge University Press.
Okay.
Let's look out for that book.
Yep.
And thank you very much again for coming to speak with
Pleasure.
us today. And this has been Obiter.
The Durham University Pro Bono Society podcast.